My name's Shelley Costello, and I'm the CEO of Creative Web Concepts USA, based out of Orlando, Florida, but we do business with clients nationwide. We're a full-time social media agency content creation company. So we are here today because this is a really important broadcast that I've been wanting to pull together again. For those of you that follow me, we did this pre-COVID, wasn't it?
Was it that long ago?
Yeah, we did this before COVID. I think it was 2019, I believe it was.
Oh.
And we had a special guest with us today. I'm going to introduce to you. But I love this topic. So today, because of everyone around in the content creation world, all my content creators, YouTubers and bloggers out there, especially my bloggers, you want to pay attention today. I really want to bring this topic to us to help us, to give us clear understanding. We did this back in the day, but things change all the time with technology. And this has even changed. Although the laws, we'll find out if the laws have changed since our last broadcast. But you can go back and watch that one. In fact, I'll put a link here when we're done. But I wanted to bring this up to date and invite my special guest, Davey J. He's an attorney with Mealy & J in Orlando. And let me just share a little bit about her without butchering it up too bad. Davey is a shareholder at Mealy & JPA. She's a member of the Recording Academy Grammys. Davey dedicates her practice to the areas of entertainment and intellectual property law. She's worked on deals with major enterprises such as HBO, Warner, Chapel Discovery, Telemundo, Sony, Columbia, and Sub Pop, as well as with indies and startups, and has represented Oscar, Grammy, and Emmy winners, along with artists and creatives who are just beginning to embark on their careers. Okay, that's exciting. That should excite everybody. You should say, oh my goodness, I'm going to have audience with a real intellectual law attorney this morning. Put everything aside, shut off your cell phones, because I have some questions for our girl Davey this morning, and I'm sure you guys are going to say, wow, your jaws should drop. And the first thing you're probably going to want to do is run to your website and start taking down every photo you've got on there, because you might, say, wait a minute, scratch my head here. So we're just going to get into the nitty gritty. Davey, welcome to the broadcast today.
Thank you so much for having me. And I can't believe it's been since 2019 since we've done this.
Yes, and needed an update. So tell us more about you that I didn't say that maybe we want to know here for our listeners.
Yeah, so I'm an adjunct professor of law at Barry University School of Law. So I teach entertainment law there. What else? I'm on the board for a few nonprofits in town. One of them's the Timucua Arts Foundation, which is a fantastic venue if you've never been. Great music. Orlando Gay Chorus. And then just, I don't think I have any spare time other than that. I'm going to be like, what do I do in my spare time? I sleep.
Okay, great. Well, thank you. She is busy all about Orlando and giving her time to organizations and events and things that really pay off and help people in our community. So that's another great big plus I love about Davey. So we're so excited to have you here today. All right, everyone, you can revisit this broadcast. So you do not need to be distracted taking notes, but you will want to bookmark this, keep it for future reference. And every time you think, oh my gosh, let me go back and look at that. I know I heard that, but this is going to be one of the best broadcasts you've ever listened to in your life. If you're on social media, if you have a website, if you're on YouTube, if you create content, if you distribute your content, if you create your own, and even if you steal it from somebody else. If you use content generated by other people, your rights within those parameters of permissions and terms of service. Okay, so Davey, I'm so excited about this. Welcome. Today, I guess I want to start at, can you define, so everyone knows, what is intellectual property law?
So basically, intellectual property is like a broad term for a couple different areas of law. So first and foremost, and especially for our purposes, is copyright. And so copyright is an area of law that protects artistic creations. So whether it's writings or photography, designs, images, painting, sculpture, all of that kind of stuff, that's all protected by copyright. So that's one of our forms of intellectual property. Another one is trademark. And so trademark is all about protecting brand and what we call source identifier. So a business or product name, logo, slogan, so anything that identifies to consumers the source of goods or services. And so sometimes something that's protected by copyright could also be a trademark, like Mickey Mouse, right? So when you see Mickey Mouse, you think of Disney. So because your mind makes that connection, it's a trademark, but Mickey Mouse is also a work of art. So he's protected by copyright for the time being. His copyright's going to expire. Other areas of intellectual property law we have are things like trade secrets. And then we have patent law, which protects inventions and methods and processes. And then also tangentially, we have something that's related to intellectual property, which is publicity rights. So name, image, and likeness rights have been a very big deal lately. So that's under that umbrella as well. So one of the things to keep in mind with each one of these areas of intellectual property is that even though we lump them together, they're very different and they protect different things in different ways. So I always tell people, think of it like vehicles, like I used my car to get to work this morning, which is a vehicle, but a boat is also a vehicle, but that would not have been appropriate for me to get to downtown Orlando in a boat. So they serve different purposes. And, so that's kind of the thought there. So we'll get into the nitty gritty of those
let's
details.
Get into the detail. Let's hit the very first one she mentioned. She's talking imagery, artwork, video, filming,
writings,
audio, music, writings. And I believe we're talking about anything you create now. This is your creation. This is not somebody else's creation. We're going to get into usage later, but we're talking about your creation. So, Davey, let's be plain for the people that really need to be plain. If we write something and it's ours, the moment we write it, we don't have to send it off somewhere to be registered, to be copyrighted. The moment we write it, we have it on paper, it's protected. It's ours.
Yes, we say your rights spring into existence the moment you make the work. Okay. So whether it's a physical writing on a physical piece of paper, or if you have a copy, if you've got Word opened up on your laptop and you type something out, that's also automatically created, that your rights have vested in you automatically. So you own it. So when people say things like, well, that's not copyrighted, I'm like, oh, be careful, because just because something isn't registered doesn't mean it's not protected. So you have rights the minute you create something.
Okay, now I do know I've heard said a lot. So let's just, what's going on out there in the world? Let's get some of that in here. So people say when you write something and you get data, let's say I'm writing an article or a blog post and I'm pulling data from different things, I know enough to cite my material and quote my material. But if we're taking little paragraphs and everything, we're just putting together our data that we're researching, and we put that into a grammar, a checker or something, there's always going to come back that there's duplicate content because there's so much on the, I've even written something original from me and had it come back as being on the internet. And I wonder, did somebody steal it? Because that came out of my head. So there's so much stuff on the internet. How do we address what's, if we write something or we research, it's out there, is it still ours?
That's a great question. So, and I love it because there's so many maybes and facets to it. And so that's such a lawyer question. We love these kind of murky things. So as an initial matter, one of the things that we're talking about, is doing your research. Well, it's important to point out that things like facts, a fact is not protectable. So nobody owns a fact. Right. So anybody can use it. Anybody could write an article about Lincoln being shot in the theater. Right. And to that end, there's only so many ways to succinctly say Lincoln got shot in the theater. Right. And so when we talk about the protections for copyright, in order to have that protection, your content must be original and creative. And copyright doesn't protect a short phrase. Or even words or titles, individual on their own. So it's got to be part of a larger work. So to say something like Lincoln was shot in Ford's theater, it's true. And I'm certainly not the first person to say it. And certainly lots of people have written it before me. Now, would that make me liable for copyright infringement? No, because that phrase is too short to be protectable. And there isn't enough original creation in that phrase that anybody would own any rights in it. So that's what we run into difficulties there.
One-liners or small, short things that we write or insert, whatever, are not protected. You can't copyright
Not
those.
on
Everybody
not on
uses
a standalone basis.
right.
Exactly.
But if you wrote it something longer and had it verbatim and it's somebody else's material, then it would be protected.
Yes.
Very good. Artwork, we know that if you make artwork, you usually sign your name. Do you have to send it into somewhere to get artwork copyright? Is that what the procedure is? Do you want to elaborate on that?
Yeah, so you don't have to send anything anywhere to have your rights. So whether it's a photograph or a writing or a sculpture, anything like that, you don't have to send it anywhere. Your rights happen automatically. However, you can register it, and you should, because registration with the Copyright Office gives you additional benefits and protections you don't have otherwise.
Okay.
And that's the only way to do it. There's this huge myth that's been going on for decades that if you mail things to yourself, that's good enough. That all that does is give you mail. If you want mail, mail stuff to yourself. That's all you're going to get. So it offers you no legal protection, no help in court. No, I swear to you, it's not good for anything but getting you mail. But if you register with the Copyright Office, what that does is it increases the damages that you could sue for, and it means that you become eligible to be awarded your attorney's fees and court costs if you have to sue somebody. And the reason why that's important is not because people want to sue anyone. Nobody wants to spend their time and money on that, but because it makes it more likely that you would, which makes the other person more likely to behave. Because now you have a bigger stick to shake at them when you say, hey, cut it out, leave my stuff alone.
Right.
So it makes it a more realistic and stronger threat of enforcement. So that's part of the large value in that. And the other part is that you can include rights and permissions contacts in your copyright registration. So somebody can look it up and say, oh, well, I really wanted to use this work that Shelley created. How do I get a hold of her? And you can put that in your registration. So it's helpful for that as well. So registration is great. I strongly recommend it. It's pretty cheap depending on what you're going to register. It's either $55 or $65. And that lasts for the entire term of the copyright, which is your lifetime plus an additional 70 years. So it's like the cheapest insurance policy you could buy.
Now, is someone just merely allowed to write like their name, copyright circle 2023, and that's 2000, and that gives notice to people that
correct.
This was created by you, and go ahead.
So whenever you do that, and it doesn't have to be registered to do that, you can use that whenever. And so what that does is it gives notice, like you said. So it tells the world, hey, back off, this is mine. And so if somebody steals your work anyways, then that's what we call willful infringement. Like they knew there was copyright protection because there was notice on it. Now, whether you understood what that means is irrelevant. Because it was there, that's what we call willful infringement. And that means the damages for infringement go up. They're higher now.
Right. Yeah, I do that a lot. I take a lot of pictures, one of the World Trade Center before it was gone, and did a Photoshop rendition of that, etched and sketched, and made 500 lithograph copies. But I did have that on it. I never had a problem with it. And then other things, I create videos because I create a lot of. I always just put that in the corner, or I put a little, like opacity, as like a little logo or something in the corner, something just to say, hey, that belongs to somebody. That's right. That's a gentle way of doing it. Okay, about the Digital Copyright Act that we live by, and telling someone a takedown notice, and legally what you're allowed to tell people to do, and what's your process, and do you run out and hire an attorney if you find your stuff on their website, and what do you do when you find your stuff on somebody's website?
So, I mean, in a lot of ways, that's something you can handle yourself, especially if it's user-generated content. So if you find somebody's video on YouTube, for example, incorporates your content, or on social media, on somebody's Instagram, on their Facebook, on whatever. So there is, like you were saying, there's a section of the law called the Digital Millennium Copyright Act. And so under that law, it deals specifically with providers, which are these websites that allow people to upload stuff to their servers. And so it specifically deals with user-generated content. And so it says all of these websites, in order to avoid liability for what their users post, they have to comply with this Digital Millennium Copyright Act, DMCA, notice and takedown procedure. So if you look on any one of those sites in their legal section, it will have a subsection for notice and takedown, or DMCA, or copyright issues, or something like that. And that's where you'll find it. and it tells you exactly what you have to put in. It'll say, what is your name? What kind of work is it? What's the URL where it was found? How does it infringe your rights? And what's your contact information? Very easy, very, very straightforward. And in general, it gets taken down very quickly after that. So that's not something you often need an attorney for. When it escalates to the point of when you might need a lawyer to help you is one, if it's not a US website, they generally don't have to follow US rules. If they're in a totally different jurisdiction and they're not here at all, or if it's not really user generated content, but somebody on their own website. In that case, they can't avoid liability with the DMCA notice because they're like, they posted it. It wasn't a user. They posted it themselves on their own website. So they can't use that little exception to the rule to get away from being liable for it. So you might want to talk to an attorney in that point. There are a lot of people who have become very aware that this is an easy way to make money, quite honestly. The number of demand letters and lawsuits for just putting an image on a website has gone up exponentially over the last couple of years. And now it is common practice to send out a demand letter and demand, upwards of $10,000 for an unlicensed use of somebody's image on a website. And certainly that number can change.
Wow.
Yeah.
So people are like trying to get money with this.
There's entire companies. It's in a whole industry now. There's like businesses that's what they do. They focus on that kind of stuff. There are law firms that's all they do is go after people for unwittingly putting content on their websites, and basically shaking them down for money, because it's cheaper to settle than it is to litigate. So even if you're right, even if what you were doing was not infringing, in order to go to court on that, like that's a federal lawsuit. It takes 2 to 3 years. It could easily cost over a couple $100,000.
Wow. So it's easier to write that check for $10,000 and be done with it because you don't have proof where you got that material. That's one reason why I was just going to interject that with our company. So we have stock photography sites and we look at the license of each one of those images we use, but we don't change the name of that image. So like if I got it from Shutterstock and Shutterstock, it's labeled, the image itself is Shutterstock 796, whatever, it has a number with it. And we keep that because when you right click that photo or whatever, it's from Shutterstock. Chances are you pay to use for the license of that photo. If you pay $50 a month for 100 photos or per photo, when you're buying stock photography, you have the license to use that photo.
And it's important to hold on to those licenses. Like when you get them by email or a confirmation or whatever, if it's only available on the website that you're using, download the license, put it in your files. Because what will happen is like somebody who might have previously licensed their stuff to Shutterstock might have moved to a different platform or sold their rights. And now the new owner or the new, entity that's in control of the rights thinks that you're an infringer because the license didn't come from them. So it's a good idea to hold on to that stuff. So if you ever need to, you can just pull it out and be like, look, I licensed this. Here's the license.
Exactly. And some people like to right click and rename that photo like Bob's Garage or give it a name for Google to enhance it. Yeah. But I tell you, never change that photo because you can always say, okay, like if you ever go to a website and you click it, you see it says Getty Images. A lot of businesses use Getty Images. So they keep that on the photo as the photo name, because I'm going to tell you, the worst thing is somebody approaching you and not being able to come up with, where did I get that photo I used on this client's website I built for them? I mean,
right. You're not going to remember like 3-4 years ago, all the work you've done, every image you've ever used, where they all came from. Like, so just save yourself the time and the stress, quite honestly, because that's what it is. It's a lot of stress. So just save yourself the stress, download the license or the terms and conditions, throw it in a folder so that you have it in the future if you ever need it.
That's a great idea. Now, what about video? Let's talk about filming and video rights. Isn't there something now that they can put in a video to detect if it's being used? I heard that.
They can they can do that with videos. They can do that with music. There's content ID that they can put in the metadata of the file. So that way it's just like the grocery store when you scan, a can of peas and the UPC label picks it up. The metadata does the same thing with these, robots and these scrapers as the content ID system pings on that and goes, wait a minute, we know what that is, so that's how they identify it. And that's a lot of times why, some things when you upload them or try to upload them to YouTube's like, nope, you can't do that.
It'll block it. Okay,
Yeah.
so we're on this video today, everybody. So we're gonna throw this question out there. So we're on the video with Davey. I announced where this video is gonna go. It's also gonna go on my YouTube channel. Yes. Is that okay? Okay.
Yes.
So within our permissions here, if I want to do anything other than the platforms I just mentioned and the places I mentioned, or do anything else, I would probably need to get her permission. I probably need to say, hey, Davey, I'm going to, that's the raw video. That's not a link to it. I can send anybody the link anytime I want to.
Anytime
but as far as taking this raw video file, this MP4, I've got her permission to do within the scope of the permissions. So when you're filming somebody, and like if you're out in public, someone said, oh, film me, I'm going to be speaking to the crowd, but I want you to pan the crowd. I will film you on stage, but I won't pan the crowd and put everybody in a video unless there's a sign out front that says, as you enter this door, please know you could be on a photo or a film, and put that out for the world without those people's permission, because they might not. So can you address a scenario like that? Like, we've got permission for this, and what I can do with this, and what about being with other people, even in a shot in a park?
Yeah. So there's this is one of those things where it can change so much based on what you have going on with the situation. But in general, we're definitely talking about people's image rights, the right of publicity. And the right of publicity is the right to exploit somebody's name, image, likeness, voice, biography, persona in a commercial manner. And what's considered commercial manner varies from state to state. And it's always based on the state of the person who's claiming the right. So where do they live? So I live in Florida, so I would be subject to Florida's right of publicity laws. So so that's kind of the rule that governs. So that's number one. You always want to consider that. And when people are like out in public, like if you're filming something and there's people walking down the sidewalk, frequently that's okay, especially if it's just in passing. But you got to be careful with how it's used. You don't want to use it in such a way that would be, if it was like in a documentary, possibly that would be okay. If it was in the news, that's almost certainly okay. But if it's in something like a commercial for, I don't know, lean cuisine, like something like that, now you're using somebody's image in connection with a commercial product, and that's not okay. Or putting it on a company's website to promote their services, probably not okay in that situation. So you have to be careful and get publicity releases. And then the other thing is to consider whether or not that person you're recording, if their contribution is significant enough that there's an argument that the video or photograph, whichever, but we'll say video. So the video that's being recorded, whether or not you as the person who's making the video are no longer the only owner of it, but instead share ownership with this other person who you filmed because their level of contribution was significant enough to make them a joint author. And when people are joint authors of a copyrighted work, then they co-own the rights. And then they have an equal right to all the revenue that comes from that. And they can each do whatever they want with the material. So that creates an entirely different kettle of fish. So the word to the wise on all of this is, if you're going to, feature somebody in something you're recording, best to have a release, like a publicity release, or like even if we're podcasting, like it's a good idea to have a podcast release so that way you can clear all those publicity rights and make sure it's clear that they don't own any of the copyrights in the content that's being created. So it's all yours to do whatever you want with, no matter what, until the end of time.
If you need a contract, just send it over, whatever. I'll sign your contract to use whatever. But I keep this within the scope. But that is great, because I do have a podcast. A lot of people have podcasts. They say, be my guest. They get on there. And I do have one. I have a little release that say, sign this, permission to use your voice on the podcast and be on the podcast. So that's really important. But I had never thought ever about somebody else being in it and them being able to claim rights to it. Maybe they had a longer time. I never thought of that. Ever.
Oh, there's a ton of case law, lots of cases where people had sued because somebody was a performer and somebody else was recording them. And so the person who recorded it said, well, I own the recording. And the performer's like, yeah, but that's my content that you recorded.
Okay, herein is the big question.
Yeah.
When you're at a concert and you're going live, or you just record it on your phone and you put it up on Facebook, and it's a well-known band singer, okay, let's pull some things out. There were some things at the Dr. Phillips Art Center this past weekend, some hip hop stuff. There were some great artists at the Amway Center recently, and you see just rolls and scrolls of people filming, both live and filming. That's not allowed.
No, it's not. There's actually like specific sections of federal law for anti-bootlegging, that speak directly to recording live performances without consent. And that's why a lot of shows, they're like no cameras, other than the flash, which is really distracting. It's the whole don't record it. That being said, some artists take a very laissez-faire approach to it. And they're like, well, this is good promotion. And people are generally not recording the entire concert. And truth be told, a lot of times the audio quality is terrible and the video is not that much better. So it's not like it's replacing.
I've seen some that are pretty good, but my question is, Facebook or some of the social media platforms tell you that you cannot do that in their, but they don't take it down. It's still out there. Maybe they didn't catch it yet.
Or didn't catch it. Yeah, a lot of stuff that you see on social media, and that's actually a good point because people bring this up all the time and they're like, how do I see these things on YouTube? How do I see these things on Instagram or Facebook if they're not allowed? I'm like, how do you see people speeding every single day?
Right.
People running lights. I saw somebody run a light this morning on the way into work. It happens. People break the law. Not everybody gets caught. It doesn't make it legal. It just means they get away with it, for that time.
That's true. That's a very, very true point. Okay, so with respect to video and filming, so if we create our own videos and somebody has a part in it, then they can claim ownership. So what if we use that video, we like upload it to websites? If the person notifies us, do we remove it when they say, hey, I was a significant part of that? Either give me some money for it or take it down. At that point, should we remove it?
That's a big maybe, because sometimes the facts might be as such that you really don't have any obligation to take it down. Because if it's a situation where you were filming with their consent, like they knew they were being filmed,
right?
Like it wasn't like some secret, guerrilla filming tactics or whatever. So they knew they were being filmed. So arguably you had consent to film them. And then, at that point, it's, if you're not using it in what we call commercial manner, so you're not selling products with it, like it's not turned into a commercial for, like I said, lean cuisine or something, then you're not really impacting their publicity rights in the state of Florida. So at that point, even if they were to say, well, I own part of that video because you used my content, you as a joint author would have equal rights to use it. So you could post it on your website. They could post it on their website.
And neither one can really do anything to the other because you have equal rights.
Correct. Yeah. So, but then there's, so that's the practicality of it most of the time. And to be clear, a little change in the facts can change the outcome. It's like chemistry, like you put the drop of the wrong thing, it all explodes. So that's a most of the time scenario. However, that being said, we also have to think of the practicality. Like, is this person going to cause a fuss? Is it worth it? Because people can always sue, like they can always file suit. The court systems are clogged with complaints that are garbage, the claims that don't go anywhere, cases that, wind up getting dismissed or settled. But even in that situation, like you still had to pay a lawyer to defend you. You still had to put up with the nonsense. And it's a lot of stress and time, which you would be focusing on better things. So, at that point, it's like, is the video worth the headache?
Yeah, if it's just a random video, why? Play music.
Yeah.
Okay, so if you create your music, let's touch on the music. What about people using your music for a soundtrack or to their video on YouTube? But see, YouTube catches copyright. You know how YouTube will put at the end, they check for copyright and they'll tell you there's a claim. YouTube does that all the time.
Oh, yeah.
But if you're not a recording artist, they're not going to have your claim.
Right.
They're not going to have you in their library to search when they're saying we're doing checks. They search and search, no issues found. Or they'll say there's a claim to this music here. If you're not a well-known singer and you wrote a jingle or a song and someone uses it on their channel, YouTube's never going to know it. But the person uses your music, then you contact YouTube and report them, or you contact them.
Either way, I mean, you could file a DMCA notice and have it taken down. And or you could go after that user directly and say like, hey, you infringed my copyright because you used my music in your video without my consent. So you have both of those options available to you. It just kind of depends on, how far you want to take it.
Okay. So really want to address all this stuff with people every day, how they use things every day, and how they, might, like I said, use famous bands or use music or use other people's material. So those are my questions. Just tell us anything else you think right now as everyday users, not as, Lady Gaga or some big name or somebody that, you're representing some big celebrity, the Grammys and the Emmys. And I know you meet a lot of celebrities, the everyday person. And we're out there all struggling. You know, the whole world's about content, it's all about content. So tell us what the everyday people, things we don't even think of. We need to know. We're out here creating this content. What else can you think that we need to be aware of? I know, you're not going to give legal advice. We know that. But what do we need to be aware legally that we can protect ourselves from getting in trouble?
Yeah. So one of the things to, be aware of is that anytime you get content from somebody else, you're potentially liable for it because you used it. So if you are, if you ask somebody, hey, that's a great photo, can I use that in my video? And they're like, yeah, sure, no problem, go ahead. Well, little did you know that they don't own the rights to that picture. You're still liable for copyright infringement, even though you thought you secured permission. So copyright infringement is like speeding. You are or you aren't. There's no like, oh, well, officer, I didn't know the speed limit dropped down to 45 a block ago, you still get the ticket, or at least I would. I don't know about you guys, but I would still get the ticket. So there's no requirement of knowledge or understanding. So your liability exists. And the same thing happens when you work with other people. If one of, somebody you're collaborating with contributes content that infringes somebody else's rights, you're liable for it just like your collaborator is. We call that joint and several liability. So you could be 100% responsible for what your collaborator contributed to the work. And so a lot of times, the best practice for these situations is to have an agreement that's drawn up that addresses that ahead of time and says like, hey, if I get sued because of what you did, you have to make me good. You've got to pay me back for all of that. You've got to make me whole. So that's one thing to keep in mind that a lot of people don't realize. Another thing is that there's a lot of misconception about what's public domain or what's free to use. People think, well, it's on the internet, it's free to use. No, that's not what that means at all. So it's, you want to go forward with the assumption that everything is protected by copyright. In the United States, right now, the rule is that if it was published for the first time in the early 1920s, now the copyright has expired. There are some things that are more recent that have expired because of quirks in the law, but by and large, what we're looking at is works that were before the early 1920s. Those are now public domain works. But you also have to be careful with that. So for example, Winnie the Pooh entered the public domain this year, but it's the original A.A. Milne version of Winnie the Pooh. So it's the Pooh with no shirt. That's the Winnie the Pooh that entered the public domain. Disney's Pooh Bear, the new version, is still protected because that's a newer work of art. So it's a red shirt on bear, user beware. If naked he be, your bear is free. So that's a little silly poem. But anyways, so be careful with the timing of all of that stuff and just go under the assumption that things are protected and it's a lot safer to move forward. And
that is great information. That is great. So, but it's just best practices overall. If you see something you want to use, contact the person. Unless they're really famous, they're not going to say, yeah, sure, give me $20,000. I mean, most people are going to give you say, yeah, permission. You can use that for this.
It is so much cheaper to ask up front than it is to pay later. I guarantee it across the board. And I see these cases all the time where people who license images out for $20, $50, even $100, they sue for $10,000, $20,000, $30,000 and get those awards plus their attorney's fees. it's bananas, but that's how it works. So, you'd rather pay the $50 than the $5,000, right? Like,
Yeah,
so.
absolutely. Absolutely. Very good. Well, everyone, I hope now if you are an artist, okay, let's just one more question before we go. I know we're running like I didn't get to, if you are an artist, if you do have a band, if you are going to cut a record, if you are going to develop an entertainment channel or an entertainment website, you are going to go into full blown entertainment. At that point, Davey, shouldn't they like call up Davey J? Okay, get a lawyer, get things in order legally for your band, or if you're going to write a script, a movie, and do this.
If you're going to be an influencer, or if you're going to create content.
Okay,
Yeah.
let's talk about that. Influencers who are contacted by these big brands to represent them. Let's just hit on those three things, real quick if you can.
Yeah. So, I mean, in general, like once it stops being a hobby and more of like, I want to do this as a job, it's a good idea to just consult with an attorney who does entertainment. Just to have an initial, these are the things you need to look out for. These are the things you need to be careful of moving forward. So even if it's just without going through like, forming an entity and getting contracts drafted and all that other stuff, if you're not ready for it, whether, like emotionally, mentally, financially, anything like that, but at least have somebody give you advice about like, here's some early advice about best practices to keep yourself out of trouble for now. That is invaluable. There are so many clients I've got who would have benefited so much from just that like 1 hour discussion before they move forward with their career. So I strongly recommend that so that you can have that advice to move forward. So that's, and then certainly other things may be needed as your career moves on, as the work comes along. As far as influencers go, they are subject to a whole additional realm of laws that people don't think about. Because certainly like they're creating their own content. So there's copyright stuff. They might be promoting or discussing, certain brands. So there's a trademark issue there as well. And then there's an additional realm of concerns because the Federal Trade Commission does highly regulate what are considered reviews and sponsorships and things like that. So certain things have to be disclosed if you're an influencer and like you're being either given free product or you're being paid to promote something. There are disclosures you have to make on the posts themselves. And there are certain restrictions on what you can and cannot say, but certainly everybody's seen like posts that have like hashtag ad, hashtag, paid sponsorship, things like that. That's required by the Federal Trade Commission, by the FTC. So those are all those additional, or some of those additional requirements for influencers. And, they also run into all other different realms of things too, because they spread out. Like nobody stays in this one little lane. They're all like, okay, I've done really good at this. Now I'm going to do merchandise, and now I'm going to do a movie, and now I'm going to do, which is awesome. Right. But each new endeavor.
I have several companies I do promotion for and get either money or services or free or offer discount code. And I always put as a partner with in video, I offer this code, and I always put the bottom. If I'm just doing a post or a picture or something, I'll put paid partnership with video or whatever it is, or Constant Contact. I always put on my email marketing because I sell for Constant Contact. I always put down there agency partner with Constant Contact. So I always do that because I want to be protected. Exactly. A lot of people don't do that. And as you move into the influencer world and people reach out to you, brands now are using people rather than mass advertising. You go to YouTube, you'll see, I know one company that's using like 25 YouTubers because you'll see all that ad on several channels. And that's how they're getting the word out to those people's loyal subscribers. So if they reach out to you to do a sponsorship or pay you or give you products, I know YouTube has that little thing, paid partnership. You have to check, you got to check that box.
Absolutely.
And, yeah. So this is great information. Davey, this has been like invaluable. I know Lauren here is watching and said this is great information. I can't wait to really share this and get it out to everybody. There's so much content right now. There's so many people creating and using content, and it's just important to know what our rights are within that when we're out on social media. So thank you very, very much. Anything else you want to say today? I'm kind of done with our questions.
Well, thank you so much for having me. I'm always happy to do it. You know me, I love to chat. So
thank you very, very, very much. Now, at the end here, I'm going to put her information. If you are in entertainment, if you are in any way looking, you just say, hey, I'm considering this, I'm doing this. I just want to find a local attorney I can go to and get information, entertainment law, and talk about that. If you need that, I'm going to put Davey's information here so that you can contact her and hire a lawyer if you need one, an attorney to help you in this area, especially if you're into content creation, creating material and putting it out there, or your business or a brand. If you're just now branding and you want to trademark your brand. I guess we didn't just hit on that, but is that a big process, Dave?
Really quick word on that, as
Yes,
not
go
to
ahead. We forgot that. Get
hijack this, but like biggest issue I see with people with newer businesses, even businesses that have been around a couple of years, but primarily with newer businesses, is they don't have a comprehensive trademark search done before they launch. And they'll just like look online, or they'll look at the state's thing, like, oh, the state says the name is clear. The state is not looking for trademark issues. They even tell you that on their website, the Sunbiz, that they're not, this isn't a trademark opinion. But I've had so many clients who started their own business and then wind up getting a demand letter because their business name is too close to another business that exists. And so they wind up having to get rid of their name, rebrand entirely. Any product that actually has any physical product that has the name on it has to be destroyed. They wind up having to give over usually their domain name, change their name on their socials, and everything. It's just wildly expensive. And I've had businesses that couldn't afford that. Like they were just like, that's it, we're done. We can't continue because that's way too expensive for the rebrand. So again, best practice is to make sure the coast is clear before you launch like that, and make sure that your brand is really your brand, and that it's protectable. And once you clear the trademark search, once you have an attorney do a full trademark search for you, then you can look into possibly registering your trademark so that's protected throughout the whole country.
And you do that for businesses that are going into business.
Sure. I do a lot.
Okay, here you go. So if you're going into business, don't slap up a logo and a name and think you're good to go. That's probably not the best way to do it. It's always best to, if you're investing money in your brand and your logos and all that, just make sure that everything is clean and clear and you've been approved, and let someone do what they do and handle registering your trademark and making sure it's clear. That way, nobody can ever come back on you with your business, because I can see that can be very, very expensive to start over. That is very, very important note there before we close. Okay, everyone, thank you for being here today. This is going to be shared a lot throughout the internet, so a lot of you are going to be seeing this broadcast, even if you couldn't be here today. Davey, thank you so much for being here, and I'll put the contact information below, and we hope to do this again in a few years. Hopefully it won't be 4 years, but we hope to come back again. Thank you so much for being here today.
Thank you.
Bye-bye.
Bye.